job in all this one. So. It's just like it, it's I feel like I never really am
Completely different.
like a lot of change.
Yeah.
There's a lot of changes.
Sure.
But I had a case with Brian
Schultz.
Actually, I was in
Oh, that's so funny. Okay. We play pranks on each other. Yeah, daily.
He must be into things.
Everybody is. Do you guys go on Fridays? Good for you. Good for you.
Honestly, like,
It is the best. I think I have my best work when I'm not worrying about it. What I'm gonna wear the next day. How I'm gonna get in time to cook something. It's just always makes me sick. Ready?
yeah, I think so. We didn't even have a lot of questions.
No, we didn't.
But that's really the spitball. It's really gonna wing it.
He's really winging it. No notes.
Well, I did print them out, and then I walked out without picking them up.
You can borrow mine.
On a client. Well, I hope you're ready to talk about telecommunications law for all 3 of us.
Yeah, because I don't know anything.
I think we're gonna.
The FTC direction?
Yeah. For consumer privacy. Oh yeah.
I'm broad.
Yeah, most 99% states that.
I hate these columns. I can't see.
When we were on the opposite side of this floor, we were like, but less light and dark color, more intimidating.
Yeah. Go for
Ramble
it.
about the states. I had to go and find the email I wrote about PADFO when it passed. I haven't thought about it since that happened. I forgot client alerts.
Is Luke here? Lovely. It's probably him right there. Yeah. Pleasure. Thank you. Hey, Luke. There.
Wait.
Good to meet you.
Hey.
You get well.
Yeah.
Glad I could make it in time for the job interview. I don't know if they told you.
Yeah.
So we just, are we giving any sort of opening things or just like launching this?
I was going to probably just introduce you all and then maybe ask you all to give kind of like a how your relationship to the subject area is. Yeah, it's kind of technically very familiar. Actually, I did tech and telecom. Catholic. It's pretty practice at
All right, everyone, we're going to move on to our second panel, moderated by Luke. So, Luke, I'll let you take it away.
Hey everyone, my name is Luke Posniewski, and I'm holding this panel, and we're going to talk about consumer privacy generally. Looking back at my note, getting ready for this, it already seems sort of old-fashioned 1 year later with what's been happening. So I think a constant theme in this panel is going to be talking about sort of change and new developments, whether it comes to technology, politics, or law. I want to introduce our panelists. So first we have Duane Pozza from Wiley Rein. We have Kamay Lafalaise from the FTC Division of Privacy and Identity Protection, and then we have Jordan Francis from the Future of Privacy Forum. So before we get kicking off in the questions, just if you all want to give a little blurb about your relationship to privacy. Yeah, Duane, I guess we'll start with you.
So Duane Pozza, I'm a partner at Wiley and co-chair the Privacy, Cyber, and Data Governance Group. My relationship to privacy. First of all, I'm ex-FTC, so that gives me the original grounding in a lot of privacy. And then I do a lot of work in the tech regulatory space, including around AI, although not just limited to AI, and obviously privacy and more broadly how to deal with all kinds of personal data is something that I advise companies on a regular basis. So it's an exciting area. One thing I really like about it is moving very quickly, so it's super interesting, and there's a lot of push and pull that I'm happy to talk about today.
Cool, thanks. My name is Kamay Lafalaise. As Luke mentioned, I'm at the FTC. I've been there since 2017, and I'm also an adjunct at GW Law. I teach scholarly writing. I'm not sure if I have any students here today, but as a professor here, I love audience participation, and I have been to so many conferences where, around this time before lunch, people get a little bit sleepy. So guess what? I'm going to get some audience participation from you all today, just to make sure you're paying attention. I will ask some questions of you all. Maybe we can do hand raising, but since I can't see some people behind the columns, we might do some yay or nays. So please expect that. And I also have to say that, as a disclaimer, the views I share today are my own personal views. I don't speak for the FTC or any particular component of the FTC or commissioner, but I will say even though they're my personal views, there's some things that I just can't talk about, either because it's confidential or because we have different policies with this current administration. So if you'd like to know more about my personal experience at the FTC, please feel free to connect with me on LinkedIn or come up to me after this panel chat, and I'm happy to discuss. So what does my work look like? The FTC's been around for over 109 years. Our mission has barely changed since, but it doesn't mean it won't change now. And we have a dual mandate, which consists of consumer protection and competition. And I work in the division of privacy and identity protection. I'm stumbling on what it is because we just say DPIP, so you might hear me say that over the course of our conversation today. And we fulfill our mandate through enforcement under our various authorities. My work mostly consists of Section 5 of the FTC Act, and we also fulfill our mandate through rulemaking, policy, and consumer education and business outreach. I'm excited for our conversation today. A lot of my work entails settling with businesses. I draft complaints, I draft orders, and I work with companies to make sure we don't litigate. I hate litigation. But I've had 3 recent settlements, Marriott International, Verkada Inc., and Blackbaud Inc., if you want to check out some of my work there.
All right. Hi, everybody. It's really nice to be here. I'm Jordan Francis. I'm a policy counsel with the Future of Privacy Forum. I work on our U.S. legislation team within our broader U.S. policy umbrella. So my work is largely focused on tracking federal, state, and local privacy legislation, specifically consumer privacy legislation. A lot of this focused on comprehensive privacy, so broadly applicable, non-sectoral privacy legislation that applies to people acting in their personal capacity. We, in the last 6 years, have had 19 U.S. states enact comprehensive privacy laws. If someone tells you that there's 20, you tell them that Florida doesn't count.
I'm from Florida.
It applies to 5 countries. It's not comprehensive.
Yeah.
Okay.
But I also support our work streams on AI legislation, biometrics legislation, health and reproductive privacy, youth privacy. So there's a lot going on in that. I've been at FPF for about 2 years now. I also, outside of my role at FPF, I'm a non-resident fellow at the Cordell Institute at Washington University in St. Louis, where I do scholarly privacy research with Mr. Neil Richards.
Awesome, thank you, everyone. So just to start, I think we should start with the topic of technology. And I guess for you all, what are some, in your mind, of the recent developments in technology that are really driving the privacy issues? And I'm sure you could say AI, but but you know, if you can try to dig down. And I guess Duane, if you want to start on that.
I'll start. Very interesting hearing what my co-founder say about this too, because we've not compared it.
It's a secret.
So I will say, like, I will say AI with a spin, but like, it is AI in the sense of the ability of AI to harness and have potentially useful applications based on large data sets and how that intersects specifically with anything that's PII or personal data. And of course, in the world of privacy, personal data as defined under state laws, defined by the FTC, it is really broad. It's anything that can essentially be potentially identified with an individual. So it's, you know, not just name and social security number, it's the whole range of things. And I think there are a lot of questions that people are dealing with who are both developing AI, but also using AI and distributing AI. And this is something that we see when talking to folks is everyone is using AI in slightly different ways, and there's not yet a clear playbook on how you can use these different tools, many of which are developed by third parties, to access personal data that you might have. So a lot of what we do is talk to folks about, like, how do you apply existing privacy laws and principles when you're dealing with a third-party AI tool, for example, that might want to, you need to read the fine print. Is it going to use the data to train the model? Well, that's a potential privacy issue. Are you putting it in an enterprise environment where you control the way the data is shared? That's a potential solution. So, like, it really does get into the nitty-gritty of it, and it does depend on, it's not AI in general, it's like specific kinds of applications that people use. And then the last thing I'll say is, like, one thing I realized over the last few years is that every company is basically now like a data company, right? Like, the ability of our technology to just suck up a lot of data and store it indefinitely unless you tell it otherwise is huge. And even companies that are not like data first companies just gather a lot of data on people. And so, like, state privacy laws and stuff the FCC is doing, like, are forcing people to think about, well, what do I do with these buckets of data? Do I need them? Like, you know, how do I protect them? I think that's very valuable and something that is important for companies to realize that are just not just big data companies.
No, I totally agree that AI is a big one, generative AI in particular. In the previous administration, we were really focused on discrimination, harm, injury, how these types of programs are, and then this was talked about in the last panel, you know, what type of information they are providing to potential commercial entities to make important decisions. And in the current administration, we are still trying to figure out how we will use our tools to regulate AI in the future, but I will say it does not seem like we will have similar policy there. And so we're thinking about it, so I'm not going to do too much, but we're thinking it through. So my first question for the audience is, how many of you, and we can do yays and nays, how many of you all have at least one social media account? So let's hear yays. Yay. How about nays? Every single one of you, okay. So in 2005, which I'm sure many of you were being born at that time, only 5% of adults had a social media account, 5%. And any guesses as to what that number was in 2019? 68%. Okay, we have one. Let me get one more guess.
95.
95, okay. 68 has it. I think that's a little bit closer than not hysterical. But about 79, you guys believe that? % of adults, 2019, had social media accounts. So just think about that expansion, right? And so I bring that up in the context of AI because social media accounts are using generative AI to store, collect, maintain, and do God knows what in the future with your information, okay? And, the context of the FTC, in my job in particular, I need to make sure they are abiding by our laws, and our law is very vague, it's a little bit broad, but our laws make sure that they're not deceiving you or being unfair in how they collect, store, and maintain your information. So how many of you have a TikTok? Yays? Yay. Nays? Yay. Oh, okay, so that's interesting. Since all of you said you have a social media account, is one person comfortable telling me why they don't have a TikTok account? Sure.
I had one,
Uh-huh.
but when everyone was trying to potentially be there or not, I deleted it. And due to the messaging before the inauguration, I decided not to delete it even though I was.
Okay, thank you for sharing. Anybody else want to share mine? Sure.
I don't agree with the idea of TikTok. I think it promotes more mindlessness than all of the other social media apps put together. The scrolling, it doesn't have any intellectual value to me, and it has business value to some businesses, so it's fine for them to use it to make money. But I just don't find it meaningful or fulfilling, and I encourage everyone to use it.
Okay. I know we got an Instagram hack here. So yeah, if anybody has been on TikTok, you will notice that the algorithm for TikTok is scary. It's like they know you. And in this day and age, you'd think, why don't all the platforms have similar AI components that allow them to make more money, that allow them to keep you on the app longer? AI has a special, or TikTok has a special AI that I haven't seen before. So it's interesting that the government is trying to regulate TikTok in particular, and I really just think that speaks to where we are now as a country and how scary this type of information and this type of programming can be. And I think a lot of it may come from fear because of how fast everything is moving. And so the division I'm in, we actually had a case against TikTok that is public, and we worked with the DOJ to try to get them to fix a lot of their data security issues. And when I talk about data security, I mean, imagine a house being a business, and they are taking a lot of your sensitive information and they're putting it inside that house. But instead of actually, keeping it safe, they're opening the windows sometimes, not all companies, but some companies are opening the windows, leaving the door unlocked, and saying, hey, y'all want some free stuff? And, that is not good for us because companies do have the means to protect your information in a secure way, but a lot of them don't prioritize it. So it's my job to create and draft orders, giving them specific directions, like, having MFA, deleting data they don't use anymore. And how that translates to the house metaphor is lock your doors, close your windows. That's how simple it is. Get an alarm system. But companies, they want to be on the forefront of let's just collect. They're really focusing on let's get more because we don't know what this will lead to. And I think it's concerning because most Americans don't recognize the harm. And the harm I think we're already seeing in TikTok because it keeps us trapped on this treadmill, thinking that we have community, thinking that we have a robot that understands us, and instead we're wasting valuable time and our attention where we could be putting it elsewhere.
So the answer for me is also AI, but in the interest of keeping things fresh, I'll talk about two separate technologies that I think about are sort of broad categories of technology. The first being privacy-enhancing technology, or PETs, which is a much more fun name. And there's a lot of examples of this. It can mean a lot of different things. In the ad tech context, it can mean data clean rooms or trusted execution environments. It can mean homomorphic encryption or differential privacy. When I was a student taking data privacy law in law school just a couple years ago, I wrote about Google's decision to deprecate third-party cookies and instead go to federated learning cohorts, where instead of doing on-device processing, putting people in specific identity groups with a certain anonymity guarantee. I don't think they're pursuing that anymore as part of their privacy sandbox problem. But there are lots of these sort of novel applications of technology to to try and make beneficial uses of data without necessarily having to disclose that, which protects people's privacy in a way. It reduces risk of onward disclosure, for example. But that being said, privacy-enhancing technologies have a lot of potential benefits. One of the things that I really love about working at FPF is that I work with a lot of non-lawyers, and there's a technologist on our youth and education team who has a really great line that I like. Not all pets are cats, compliance-avoiding technologies. So there are a lot of open questions about, even if you're using a privacy-enhancing technology, is that still getting you out of, say, cell share restrictions under the CCPA? Maybe, maybe not. But that's something to keep an eye on as we sort of develop a lot of these technologies, and we see a lot more research funding going into that. And the second example I'm going to give, and I'm going to launch into some more privacy history, is on universal opt-out mechanisms or opt-out preference signals. American privacy law has really been dependent on privacy as control as the dominant regulatory framework, really going all the way back to the 1970s and the advent of the fair information practices. And this really is the idea that you should have control over your privacy, and that's largely through consent requirements, individual rights like the ability to access correctly, transfer your data, and increasingly the ability to opt out of certain data uses. Under the state comprehensive privacy laws, that typically looks like opting out of selling your personal data, targeted advertising, or profiling for significant decisions. And there's been a really growing body of scholarly work, even I, in my work outside of FPF, contribute to this, when I write about information fiduciary duties in privacy law. This idea that privacy as control is really overwhelming. And it's hard for consumers who have so many commercial relationships. You're not making privacy policies for everyone you interact with. How can you possibly manage that relationship and use these controls effectively? The response that we're seeing to this is some lawmakers are trying to move towards more substantive default protections, but we're also seeing the rise of this idea of people exercising their privacy rights on a default basis through a technical solution, and that looks like universal opt-out mechanisms or preference signals. This is mandated under a number of the state laws. California actually has legislation trying to make this a requirement for all browsers and mobile operating systems to offer this as part of their service. And it's just the idea that you activate this signal and every business that you're interacting with gets the signal and knows to opt out of those things on a default basis. And that offers a lot of opportunities to maybe reduce some of that burden on the individual to not have to protect your privacy so much.
Awesome, thank you all. Good stuff. So next topic I want to talk about now is sort of the legal changes going on. So I think there are sort of two threads I want to touch on here. First is just pure what the Supreme Court has ruled recently with the administrative state, and then second, how privacy regulation is going. I guess starting with sort of the FTC has had the commercial surveillance rulemaking, which no longer seems to be in play, but I wanted to hear all your thoughts kind of on both of those strands with the actual court cases and what that does to the law itself, and then also administrative and regulatory efforts towards that end. So I guess maybe we'll start with what?
We can rotate.
Yeah.
Oh yeah, I was gonna pass it to me.
So with political transitions, there is a certain amount of time that it takes to change course. You can think about an agency, particularly like the FTC, as a cruise ship. So you see a massive cruise ship going along its way, and then when you have to change course because of a different administration, it takes time to shift. And so right now that's where we are, at least internally. We have heard about these cases, but I don't know if you've heard with the FTC, 2 commissioners were recently removed from their posts. And it's been interesting times, but we do know that our commercial surveillance priorities are no longer that much of a priority, but it doesn't mean that it won't be in the future. I think they're just trying to bring on and onboard new politicals who want to understand the landscape before making final determinations. So we are hearing about Supreme Court cases, and honestly, we just haven't had enough time to digest and figure out a policy yet. At least that I can talk about.
So I'm going to pivot a little bit and not ignore the question, but I think I try not to make predictions at the best of times, and I certainly don't want to make predictions about this administration. And I'll defer to my colleagues' expertise in the FTC. I want to instead talk a little bit about Congress. I think there's much more certainty around changes and what Congress is making plans on with privacy legislation. And in particular, the FTC commercial surveillance rulemaking was going on for a long time. If you go back and you look at Chairman Ferguson's nomination hearing, Commissioner Holyoke's nomination hearing, they emphasized repeatedly, Congress should be working to pass a comprehensive privacy law. And that's kind of up in the air, but what we do know is that Congress is working on this. Senator Cruz, who's now the chair of the Senate Commerce Committee, has indicated that maybe comprehensive privacy isn't so much of a priority, but he's very focused on kids' privacy, and in particular social media. His bill, the Kids Off Social Media Act, COSMA, which is a bad acronym, that I believe passed the Senate already, so that's something that they're working on as a priority. But in the House, we are seeing actually the House Energy and Commerce Committee working on privacy. And they're very clear that the bills that have made it pretty far in the last couple of years, the EPA in 2022, the APRA last year, that model is gone. They're wiping the slate clean. Instead, they've implemented a new working group to work on comprehensive privacy starting kind of from ground zero. And there are a lot of indications that they're going to look to the states, in particular, maybe Texas's law as a basis going forward. But I would keep my eye on Congress, and it's really easy to sort of get used to the idea of congressional inaction. But I would take it seriously when they say that they're working on these things and they're signaling what they're thinking about.
Can I add one more thing before?
Oh,
Sure. Yeah, I just think we are thinking about children's privacy. We've thought about children's privacy throughout different administrations through the use of COPPA, which stands for Children's Online Protection Act that we used to rule under the FTC. And a recent really interesting case in the previous administration was the Amazon Ring, Amazon Alexa case. I worked on the Amazon Ring case, and I talked to individuals who were actually victims of data security and privacy breaches in Ring. So some really creepy stuff happened there where people would put up their Ring cameras and they wouldn't have multi-factor authentication. So if you have a Ring camera and you use your phone to use the app, I encourage you to add multi-factor authentication. It's an extra step that could save you a lot of headache. But I think in our relief with Amazon, we might have required them to ask people who use the app to have it. Before, they weren't asking people, they were just letting them use it without MFA. So in that occurrence, there were several people who had hackers break into their Ring and watch their children in their cribs. And in some cases, they were talking to toddlers, telling them that they were Santa Claus, or asking the children to do weird things. It was extremely disturbing. I talked to kids who suffered through it, and they had to get counseling for the trauma. So these nefarious things come up that people don't often think about, but they do cause real harm. And a simple thing like locking your windows could help in the future. So I just did want to bring that up in terms of children's privacy. We are continuing in this administration to protect children. That is a big and prominent policy, but yet to be seen, the types of cases that we will be going after under this administration.
And the status of COPPA rulemaking.
Oh, yeah.
I'm hearing is maybe back in play.
Yes, so we did start on that in the previous administration. We were updating our COPPA rule this was a very big endeavor. This took several years to update this rule, and I think we're at the tail end of that. And I didn't work on the rulemaking part, but we're really excited about it.
Right, it was finalized, but not yet published in the Federal Register.
Exactly.
And maybe that's all you could say.
Yeah, that's all I can say.
But yeah. And I would say that was, the changes were bipartisan with the chairman having some things he wants to tweak, so.
Yeah, I think it'll come out.
Yeah. So I'll talk about states, because that's a piece that we haven't really talked about. Although Jordan could talk a lot more about that, I'm sure, too. But really, looking for the kinds of things that our clients and folks we talk to are looking at. So much of the activity is in the states. So obviously there are now 19 comprehensive state privacy laws. There's a number of other privacy laws that are not comprehensive that are passing. There are one-off law, more specialized laws, Washington State has My Health, My Data Act, which is about all kinds of health data, and it's written very broadly, also has a right of action. So there's lots of stuff going on at the states. I don't think that is unrelated to Congress not having passed a law. In fact, you can go talk to state legislators. They are acutely aware of Congress not passing laws, and that has been the impetus for, I think, just so many of these. And there's even more coming look like they're coming this year. I think that's critical in a number of ways. One is it is like parameters on what companies can do around their management of personal data, but also we're now starting to see enforcement, and that is something that took a little while. California is ramping up. They have an odd system where they have two different enforcers. They have in theory the AG and their privacy agency. We've seen Texas actually, their privacy law went into effect, I think, on July 1st, and they've been off and running on enforcing their law. They also have different laws there too as well. So I think that's something that is worth keeping an eye on, not only because there are these existing privacy laws, but each of these states has the equivalent of the FTC Act. So it is a law that prohibits unfair or deceptive acts or practices. And historically, a lot of these state laws have just mirrored whatever the FTC has been bringing, and I think probably the FTC's been out in front in developing the legal theories as applied to privacy that might apply there. But even if the FTC pulls back and says, hey, maybe this isn't like a theory that we're going to adopt under like unfairness authority, which is a separate thing we can talk more about, states can, right? And often the state laws have broader unfair competition laws that can reach other things. Now these can be contested, they can be litigated, a lot of them settle. But so I do think that like keeping an eye just on the federal government is sometimes missing all of the practicalities of what's going on at the state level in terms of privacy regulation. Having a patchwork approach, I don't think it's ideal. There's a lot of complications and difficulties for this for a lot of reasons, but it is currently the world we live in. And one more thing I'll tie briefly to telecom is that there are actually different jurisdictional reaches. The FTC, for example, has limitations on common carriers, which affect things like telecom providers as defined by common carriage, transportation, HIPAA. There's lots of different carve-outs. States don't necessarily have that issue. This is a law review note waiting to happen here. There's various preemption issues potentially when states try to regulate those areas that have federal regulations, but that's worth looking at too, because states actually have much broader laws than you would see just like the FTC.
Yeah, if I could piggyback on that really quick, I think Texas is a really great example of this blending of different enforcement authorities. In particular, in January, they announced a major enforcement action against Allstate and several of its data broker subsidiaries regarding the collection and use of driving behavioral data, so like location data, accelerometer data, other things, without consent. And what's really interesting to that is that they brought claims under a number of different authorities there. The data broker subsidiaries, they were doing enforcement under the comprehensive privacy law, but against Allstate, the parent company, because insurance institutions are exempted from that law, they actually brought similar claims under their unfair insurance law. So you're seeing, in particular in Texas, using every authority available to them to make sure they're going after everyone in that ecosystem.
Awesome. So next topic I want to talk about are privacy myths. So I guess for you all, are there any privacy myths that irk you especially, and something that you think is worth dispelling? And I guess we'll start with Jordan on this one.
Yeah. I really recommend, if you're interested in this, the book Why Privacy Matters by Dan Richards, who obviously like to work with. In my scholarly capacity, so I'm a big fan of his work. But it really goes through a lot of these ideas of, privacy is dead. Well, no, it's not really. You're still, we're enclosed, you live in a building with walls to protect yourself. We protect our privacy in a lot of ways. But in general, to just kind of take it more abstract as opposed to specific myths, I think it's really frustrating when people don't think about what they care about with respect to privacy. And in particular, when you hear things like, oh, I have nothing to hide, well, is hiding the same thing as privacy? Is secrecy the same thing as privacy? And thinking about, especially like we're talking to lawmakers, what is the specific thing that you're trying to protect against? And I think to get into an example, one trend that I'm tracking in legislation right now is this new exemption with respect to biometric data. We've seen it in like proposed BIPA amendments over the years. We're now seeing it in some comprehensive bills. But it would essentially exempt from the definition of biometric data, which often requires opt-in consent to process. It's no longer biometric data if it's converted to a mathematical representation from which you can't generate the underlying measurement of like the iris or the face. And that's a really interesting question. Should you exempt that? It's good to try and get people to take reasonable security measures, especially if your goal in protecting privacy with respect to biometrics is the security risk that, oh, if I'm not encrypting this data, if I'm not hashing it, and someone gets access to it, well, then my biometric security features are compromised. If that's the privacy risk you're responding to, then this makes sense. But if the privacy risk you're responding to is sort of broader concerns about surveillance and autonomy and your personal freedom, say the use of facial recognition in public spaces, then maybe it doesn't make sense to exempt that data and instead require opt-in consent for it. So being really specific about what does privacy mean, I think gets you much further in crafting actually meaningful protections. And then for a little tangent, one big pet peeve for me is just people who don't understand the difference between, say, personally identifiable information and personal data, especially as it's defined under a lot of the new state laws, which is much broader than traditional concepts of personal information. And in particular, I heard a data broker on a podcast say once that they don't collect personal information because the location data they have is all tied to IP addresses or MAIDs, like mobile identifiers on phones. It's like, no, that's personal data. So I think just getting out of that mindset for some people, whenever I see it and people confuse it, it bothers me.
Yeah, I totally agree. The notion that privacy doesn't matter really, it bugs me, but I can understand why people say that in this modern context. So going back to social media, I'm going to pose another question for you to spice things up. Yays or nays? Yays first. Who's of those who has a social media account, is your account public? Yays. Nays? Nay. Okay, well you guys are smart. You're not the average. You're not the average social media user. LinkedIn, of course. You see what people post. They post crazy stuff on LinkedIn now. So yes, it's social media. So does that change anyone's answer? Yes. Okay. So let's do one more time. Yay is a public LinkedIn account. Yeah. Okay. So say like 40% of the audience, maybe 30%. Back in my day, and I am older than I look, when somebody created a social media account, it was private by default. How many of social media users do you think today have their social medias as public, percentage-wise? Bingo. You get a free water. 50%. Okay, and I'm talking when I was growing up, maybe 3%, because that was like, whoa, you don't care about the life. There's stalkers out there. There's people that can come kidnap you if your social media is public. So, and that's just in a span of 10 or 12 years, where people are growing more comfortable with the idea that, yeah, it doesn't matter, but also most people don't know, especially older communities. They sign on to Instagram, they sign on to Facebook, the default is public, and they didn't even realize that they can make it private. So, you know, what's the harm? There's a lot of harm. In the Amazon Alexa case that DPIP brought recently under COPPA, we found that Alexa was listening in on conversations and actually recording children's voices. And so sometimes children would ask, hey, Alexa, play a Bluey song. I don't know anything about what's going on in that context, but play something from Bluey. And Alexa would record their voices without parental consent and store it in the cloud just to use it, and I see that face, right? It's really creepy. Use it in the future for an undetermined reason, you know? And so we actually had a term of relief where we asked Alexa to at least ask for parental consent before doing that. And so people who think, you know, who cares if they're taking my privacy? Well, in the children's context, there's definitely harm. There's also harm in the adult context. We're working on a case called Coachava that's making its way through federal courts. A judge recently said that geolocation privacy tracking could be a privacy violation because it's a harm in and of itself. There was a case where I think it was an app, it might have been Grindr, where they were using geolocation data to follow people, and it led to, I think, a priest being outed as gay because he was meeting up with somebody on the app, and that information was sold to data brokers, and so somebody was blackmailing this person and threatening to release that information, and it ruined, you know, that person's career. So there's definitely harms. So it ties back to why I feel like people not realizing that privacy matters is something I hope that we can actually dispel in the future.
So we're going to go in a slightly different direction to something we haven't talked about yet on this. I don't know if it's a myth or not, but one of the policy debates around, particularly at the state level, is who should be enforcing privacy laws. There's been a big argument, and I think there is an assumption among many, that if there's no private right of action for people to bring lawsuits under privacy laws, that they are somehow toothless or ineffective or should not go forward. And this has been actually a big reason why Congress has not passed a comprehensive privacy law, is that a lot of the substance there might be bipartisan consensus on, but the enforcement mechanisms to date there have not been. So my personal views are generally that the privacy laws are best enforced by government agencies and not by independent private rights of action. And one interesting thing I think comes out in this conversation is a lot of this is technical. A lot of this is policy judgments about trade-offs and guardrails around use of this broad swath of personally identifiable information. And it's not the case that we're going to turn all this off, right? This is our modern life. So there's going to be guardrails around it, right? There's going to be regulations around it, and there'll be gray areas. But what you see in cases, and there are some laws that do have private rights of action, is that's not the concern of why a case gets brought, right? That's just the economics of how private litigation works, is that it can be based on technical violations, the incentive to settle if there's not really a public policy issue around a privacy violation is just not there, right? I mean, it's all depending on whether or not you can get something out of a jury trial or not. This is played out a lot in Illinois, which has its law BIPA, which does have a private right of action, and it's been around for probably a decade now, and has a lot of litigation. So I raise this just to say that is an ongoing debate about the best way to enforce these laws, and you see it a lot in the states. Most states, the states in passing their comprehensive privacy laws have not done private right of action, but it still pops up under consideration every now and then, and it's I think an ongoing issue.
And now I have some sort of individualized questions for you all. So I guess I'll start with Duane here. I guess, what do you see as the most difficult compliance issues that you see with clients in this area, whether it's specific state laws or federally or,
So I mean, at a high level, I mean, one interesting thing about the work I do for clients is often it's large organizations where it's not just the client, right? It's you're dealing with people who are there's the business side, there's compliance people, there's lawyers, there's salespeople. It is an organization. It is a complex organization. And so the folks in-house are actually doing things to try to manage what's going on with compliance with a whole bunch of laws, including privacy laws. And we're there to help them. But it gets complicated. Not everyone always knows what's going on. You have to dig to figure out what's going on a lot of times. And the second thing is the changing nature of the law is something that is difficult, especially as more of these laws come into effect. And you always have to keep on with it. One thing that also tie into telecom is we see now a bunch of actually private rights of action, plaintiff side cases on website pixels, being brought under the basically state wiretap acts. So they're basically analogizing website pixels to trap and trace devices or other sorts of core telecom, you really would stick it on a payphone and intercept the communications, right? And all this is being litigated in the courts, and it's really, I think, trying to squeeze a lot of these new technologies into this old model. But what it does is it creates this tension with actually existing state privacy laws, which treat things like website pixels a certain way, or cookie banners, or something like that. But you do see a push towards trying to overlay different kinds of rules that would have different sort of consent requirements on different legal theories. So I think that is a challenge, an operational challenge for pretty much anyone, a company or even the law school that wants to have a cookie banner or something like that. what do you follow? And at some point it becomes like a risk assessment of how to read some of these requirements.
And then, Kamay, kind of on that topic of sort of tying in telecom, as federal regulators, do you ever see with sort of a lot of digital technology being used in a lot of ways, having to collaborate or having pushback, I guess, with other agencies trying to regulate certain areas and
Like with the
technologies?
FCC?
Yeah, like
For
FCC
example?
perhaps.
Yeah, so I don't know if I would say pushback. We certainly collaborate with the FCC. Has anyone ever actually heard of a case between where the FTC and the FCC work together? Well, I haven't either, but it doesn't mean we're not working on it. It's because we have a lot of internal non-public matters, and it's actually pretty recently that we signed an MOU or a memorandum of understanding with the FCC. Actually work together on these types of big matters, and an example of a big matter might be if there's a telecom company, for example, let's say like Verizon, T-Mobile, or whatever, and they had an experience where they had a data breach, okay, and that is not uncommon. So in that situation, we would have calls with the FCC and try to figure out how we can get the company to settle and have some injunctive relief and talk about our respective authority and how to include it in an order. So that takes time. And if you've ever worked on a group project, it's not always easy, but I think that's where we are now when it comes to the FCC and the FTC and how we communicate. But we want to give actual injunctive relief that's going to help people and not just force companies to change because we're saying that they should change. And I think that's why it's a little bit difficult to do so, because our authorities do have some overlap, but we want different things at the end of the day, and that takes time. So I would just look out for that in the future, because we are talking to them, and we talk to them on a monthly basis, and we have a good relationship, which I can't say for every agency that we work with, and so that's where we are.
And then, Jordan, it's kind of outside of official forums like Congress or like rulemakings, where do you see a lot of the policy discussion or I guess like progress being made in sort of debates about the state of privacy law?
Yeah, I mean, the states are extremely active on privacy. I tell people that I do federal, state, and local privacy legislation work. It's 99.9% state work. We already have 19 state comprehensive laws. We have huge sectoral laws like Illinois' BIPA, Texas' QB, Washington, My Health, My Data, all sorts of laws. And I'm already this year alone tracking more than 250 state bills just in the very narrow type of consumer privacy legislation that I track. And these state lawmakers are really shrewd. Every so often, you watch a hearing and no one in that room knows anything about privacy and it's immediately apparent. But most of the time, these are people who are extremely informed. Some of them have experience as attorneys, some of them working in privacy and compliance work. And a lot of them know what they're talking about. And while we've got a general sort of regulatory model that a lot of the states have coalesced around, you also see them taking influences from other places. I know from attending a lot of privacy conferences, like if you went to IAPP's Global Summit last year, a number of state attorney general representatives were there talking about they all communicate with each other. They're sharing information, they're coordinating investigatory sweeps. So the enforcers are talking to each other, the state lawmakers are talking to each other, they're constantly at conferences, symposiums like this, and they're getting information from a variety of sources. They're talking with trade association groups, they're talking with advocacy groups, they're talking with nonpartisan think tanks like FPF. But they're also taking influences from different jurisdictions. Congress might not be doing a lot on privacy legislation, but that doesn't mean it doesn't have a trickle-down effect. In 2022, it was really notable when the ADPPA became, I believe, the first comprehensive privacy bill to make it out of committee in Congress. It didn't get enacted, but we see its influence in the state legislation. In particular, Maryland became the first state last year to do something very different on data minimization. The general rule under the state comprehensive laws is you have to limit your collection and processing of personal data to the purposes you disclose to the consumer. Maryland changed that rule and instead tied it to what's necessary to provide a requested product or service. That language you can tie directly to ADPPA in Congress in 2022. So you see them taking and borrowing these concepts. And you also see global concepts influencing them as well. Like California has a cooperation notice of understanding agreement with the French DPA, CNIL, they go to the Global Privacy Assembly, which is the global forum every year for privacy enforcers to talk. So they're borrowing global concepts, and they're also borrowing local concepts. The first panel talked about New York City has a law, Local Law 144, that regulates high-risk AI systems that make employment decisions. We see a wave of that kind of legislation in the States, and a lot of them are looking at how does that law work in New York, what are the friction points. Civil rights groups talk about maybe the law, when it becomes effective in terms of how involved a human decision maker is in. That's something that New York kind of pioneered in their local law, and state lawmakers are looking at that and trying to figure out what lessons can we learn from it. So they're looking for all sorts of sources.
And I think we have a few minutes before starting open questions, so just wanted to ask, if we're talking about American law, I feel like you can't get through any conversation without mentioning free speech. So I was curious to hear your all opinions about data as speech and whether uses of data have some sort of First Amendment protection that might limit the scope of privacy laws.
Data in general?
Just, I guess, the collection and use and processing of data has First Amendment implications that might affect the scope of privacy laws. If any of you have thoughts about that.
I mean, just off the top of my head, I know this administration is really concerned about free speech, particularly in the context of not having government get in the way of free speech, and how tech companies in particular use data that they've collected and maintained. But we have not come out with any direct policies involving that. I think it's an interesting question. I don't know if anybody has a good answer for it. I think that when you think about, X, for example, this has been a conversation that's been happening for a while. How we use data that we've collected, or companies use data that they've collected, and what form that they create something new from it. We want, as the government, we want to encourage innovation. We want people to be able to, or companies in particular, to be able to push the envelope. We just want them to do it in a way that makes sense and is fair to consumers, in a way that they're not lying to consumers. And I think that we support free speech, of course, but that's not even, the question that we are looking at when we are doing our matters, but it's a response from companies we often hear. What you're doing is prohibiting our free speech. And I think it's a question that we're grappling with today, and we're working through how to make sure we don't do that. But personally, I don't think it's a good response from the other side, and I'm interested to see as a legal community where we end up in the next few years, because I think there will be more conversation about it.
I will say, under most privacy model laws and ones you see in states, there are exceptions for publicly available data that have different sorts of definitions that try to accommodate First Amendment interests of stuff that is already legally in the public domain, right? Not something that was hacked and put into the public domain, and they draw distinctions. I don't think we've seen a lot of testing of really the limits of that yet, but I do think it's interesting when it could. And of course, then there is an entirely separate debate around a bunch of laws that are probably kind of outside the scope of this panel, which are these laws that seek to protect or do age gating for kids to access content online, which have resulted in lots of First Amendment litigation. I think the interests there are not at least purely privacy interests so much as other interests around children that might be adjacent to, but aren't directly driven by privacy, but that's certainly in litigation.
Yeah, and I would say that despite, over 6 years now, we've got 19 state comprehensive laws. Only a few of those have been in effect. We've got very few enforcement actions, a couple out of California, the recent lawsuit brought by Texas, but we haven't seen much enforcement. And I said earlier that I don't make predictions. I'm going to make a prediction and break that rule. That I really think as we start to see enforcement ramp up, you might see a commercial speech challenge to one of these laws. And I think about in particular, the California Age Appropriate Design Code is a youth privacy law in California. It was originally sort of a code of conduct, I believe, in the United Kingdom, that they enacted the law in California. There were a lot of concerns right away about how compatible is that First Amendment. You've seen states who've since passed age appropriate design codes like Maryland to make some tweaks to try and adjust that. But in California law, was enjoined in the initial district court opinion, made a lot of really sweeping proclamations about privacy's relationship with the First Amendment. In particular, I believe in it, the district court judge said that requiring companies to do a data protection impact assessment is compelled speech. And I think they've walked that back in the Ninth Circuit decision. But there are sort of questions about these really key tools in privacy protection. Impact assessments have been around for a long time. But are we going to see increased challenges to those as companies feel the requirements of it more? Maybe.
Awesome, thank you all. So we have a few minutes left, so I want to open it up to any questions from the crowd.
Hi, thank you all obviously for being here. I'm curious if you've seen how data ownership plays a role in any of the things that you talked about, like who actually owns the data that the company is collecting, is it the individual, is it the company once they've converted it, and how that affects legislation and regulation?
At least from the FTC's viewpoint, we believe the data belongs to the consumer, and that's why we take such a stance of expecting companies to take good care of it. And even when that data may be converted somehow, I personally don't see instances where companies are taking the time to convert it much, except in the context of generative AI, which of course that pulls from different sources, and then they create something for the end user. But we don't really talk about it in the terms of data ownership, because this is your information, and it's your right to have your information treated with care, particularly in the healthcare circle or the healthcare field, because in my division we also use HIPAA, not in the sense of we are using the actual statute to bring cases, but if a company or an entity claims that they are HIPAA certified or HIPAA compliant and they're not actually following that, we use our deceptive tool to include in our orders allegations that state, you were violating Section 5 of the FTC Act because you're in fact not taking care of people's information the way you should, and you're claiming to use HIPAA certifications or standards, and this is how you make sure you don't do that. And to not do that, you take off that certification, because when people see a HIPAA certified or HIPAA compliant tag or emblem on their website, they have trust that their information is going to be shared, because they still own it, shared with that entity and still maintained properly. But that's often not the case from what we've seen.
I would just add that I think a lot of it that I see come up, the ownership is around IP. It manifests from a legal perspective more in IP rights as opposed to the language or the laws around privacy. So there's important issues there, but they just manifest in a slightly different way.
Good question.
Thank you for doing this. My question is kind of about the international aspect of some of these things. Obviously, social media, TikTok, and the concerns with information being sold to foreign governments. How does kind of the international aspects of a lot of these corporations, how does that come into play for regulation, enforcement, all that kind of stuff?
So for the FTC, there are complications there. Ordinarily, we can pursue or go after companies that are within our reach. Technically, that's United States, but we do have some kind of long arm ability to prosecute companies that are in the United States but operate internationally. I saw that in my Marriott International case, and Marriott has a ton of hotels here, but globally they have hundreds of hotels. And to make sure that our authority would be in place in the places globally, we had to go to our Safe Web Act statute and kind of incorporate that into our orders to make sure that what we ask them to do in the States would also be incorporated through their contracts with other communities globally.
Yeah, there's another aspect of this as well, which is which we haven't really touched on, which is there's a move towards restricting the transfer of U.S. personal data outside of the country. So it's a couple things. There's a law called PADFA, I think it's Protecting Americans' Data called the foreign adversaries
Yep.
or something.
That's exactly it.
That's right.
There you go. It was passed last year. Haven't seen any enforcement actions yet, but it's enforced by the FTC, which is really interesting because it is it's a law that affects. It's defined to affect data brokers, right? So think of data brokers who are not first-party collectors of data, limiting their ability to sell certain sensitive data to countries of concern or whatever they use, which includes China and I think a few other ones. That is interesting. It's being enforced by the FTC because you don't typically think of the FTC as a foreign data enforcer. But now there's another rule that's going into effect in a couple of weeks from DOJ, which is also kind of an odd place to put a rule. It's about bulk sensitive data transfers and government-related data transfers. And it also actually extends beyond data brokers to first-party collectors and says that if you have a certain amount of this U.S. personal data, you have to, first of all, you can't sell it to China, Venezuela, Iran. But then also it puts on additional restrictions and contracts if it's just even leaving the country. So there's supposed to be FAQs coming out about how to interpret this rule that's going to be in 2 weeks, which we haven't seen yet. But I think that it's a developing area, and I think that under either of those statutes or whatever else you see, there are national security concerns, but also real privacy concerns around making sure that at least large amounts of U.S. personal data don't get shipped overseas. And so I think that's an area to watch, and also exists sort of independently of the dynamic that Jordan was talking about earlier in terms of drawing from these separate privacy regimes of Europe, for example, which also have a lot of protections on.
Yeah, and I find this data localization issue so interesting, and in particular PADFA and the DOJ bulk sensitive data transfer rule, because those came really close on the heels of each other. The Biden administration issued an executive order on sensitive data transfers in I think February of last year, and PADFA was introduced in March, passed the House immediately, sat for a little bit, and then in the course of 3 days was added to a larger foreign aid package and passed. I got a very surprising text at 11 p.m. at night saying PADFA was added to the foreign aid package. Read it right now. And so clearly, I think they're responding to broader national security concerns. I think members of Congress have talked publicly about they were having a lot of national security briefings at that time. So really curious about how that happened in such a short period of time.
Yeah. Troop movements is another part of it that
Troop
they were worried
movements.
about. Yeah, because it involves military data.
All right, I think we have time for maybe one more question, if anyone has one.
They're hungry.
Oh, we got one.
So our previous panel talks about using algorithms in hiring. Do you see any potential privacy issues there, and how you kind of address that?
I think it's a core privacy issue. When I think about the things that got me interested in privacy, I think the use of your personal data to make decisions